Right, and remember, welcome to the Computational Science Colloquium series. Today we have a different type of talk, but it's something that is actually hopefully very relevant of interest to you because it deals about how to regulate the use of artificial intelligence. So I have the pleasure to welcome Professor Ugo Pagallo, who from Turin University, and he's going to talk to you about the introduction of the AI, just basically it's all Europe and ambition and drawbacks.
Thank you very much, Jose. Thanks for the invitation. It's a pleasure to be here with you. And the overall idea is to give you some ideas about what's going on in Europe and why this new regulation, which is going to be at full speed, maybe, on August the 2nd this year, can be relevant also here in the US. And here's my premise. There has been a sort of a tsunami in Europe concerning the regulation of digital technologies. This is only a sample, a tiny sample of what's going on in Europe. Madness. And of course, I won't talk about all this, but I'll be dealing with the AI Act. Here you have. And the General Data Protection Regulation, the so-called GDPR. First, because they are strictly connected, and second, because maybe you heard about the GDPR for a very good reason. The GDPR has triggered what Anu Bradford dubbed as the Brussels effect 14 years ago, namely the fact that this European regulation has exerted a unilateral effect on the rest of the world, for better or worse. Meaning that, for example, why this unilateral effect? It's not only, and I would say, it's not a matter of power. In many cases, it has been a matter of self-interest of high-tech companies, meaning that once you adopt the strictest rules across the board, you most of the time are okay with the rest of all possible jurisdictions. And the GDPR is from 2016, so has already 10 years. And the GDPR, however, drew on the previous European Data Protection Directive, in this case from 1995. So we have 30 years of strict data protection legislation. First directive, now a regulation. And just to give you an idea, even China's data protection legislation has been inspired by the GDPR. I'm not saying they are following suit, but the model, and we can start discussing whether the California data protection and consumer regulation has followed the same path. Maybe no, but for example, from a European perspective, it is even bizarre that in the US, I mean US federal privacy constitutional law, there is this, for a European, even bizarre equalization of privacy and secrecy, which is absolutely not the case if you are dealing with data protection issues, because how to put it, I can pretend protection over my data, meaning access to data and control over that data, regardless of whether that data is secret or not. And this kind of approach, is very similar to some legislation here in California concerning data protection issues. So, in a way, this is our premise, because we may ask whether the AI Act will trigger a new Brussels effect. What's particular about the AI Act is the fact that it's an all-encompassing legislation. In the legal jargon in Brussels, it's called a horizontal legislation, meaning that regardless of the specific sector you're dealing with, drones, medical devices, blah, blah, blah. This is the general regulation for whatever kind of AI system or model you are developing, using, and the like. So there has been a vibrant debate in Europe whether this new legislation will have a similar effect compared to the GDPR. Before answering this question, let me give you the overall picture of the AI Act. Namely, the AI Act is a risk-based regulation. Here the risk-based approach is not a strictly empirical approach. That is, it's not strictly related to probability of events, consequences, and costs. It's most of the time what the legislator deems as politically unacceptable or risky. And at the very beginning, the proposal of the European Commission in April 2021, and this is the final structure of the legislation. But at the very beginning, the very idea was to distinguish 4 different kinds of risk. Starting with unacceptable risks. And so, according to Article 5 of the regulation, that doesn't matter, certain uses of AI are prohibited in Europe. For example, real-time biometrical control of people in public spaces is prohibited. There is a list of exceptions. In very strict cases, the police can use these kinds of AI systems previous the authorization of a justice. But generally speaking, certain uses of AI are prohibited because they are considered unacceptable vis-a-vis the European Charter of Fundamental Rights. So, some uses are banned. Then we have high risk uses of AI. And for example, if you are using AI systems in the judiciary just to help justices or lawyers, if you are using AI systems for hiring people, if you are using AI systems for educational purposes, if you are using in several cases, that kind of use of technology is considered, for better or worse, high risk. And then designers, manufacturers, deployers, and in some cases even end users of these systems have a series of duties and obligations. Then we have limited, the category of limited risks, mainly chatbots. Here, the main obligation has to do with transparency clause. For example, if you are interacting with chatbots, you have the right to know that you are interacting with an AI system. By the way, this is connected to the GDPR because there is a general right in Europe concerning our right to have a human intervention for whatever kind of automated decision-making process. And finally, there is the other than lower risk uses of AI. And for these cases, there is no obligation. So this is the general picture. But of course, there's a long list of problems. First, to say the least, this is a very complex text. We are dealing with almost 100 articles, 200 pages of legislation. Think about a very detailed list of instructions by IKEA to set up your building. Very detailed. So in many cases, either you are a super expert of EU law, and even in this case, I bet you're gonna have some hard time in order to understand how to put together all these pieces of legislation. Because, for example, consider the risk-based approach. Also, the GDPR is a risk-based regulation. And so you have two general risk-based regulations, the GDPR on the one hand, the AI Act on the other hand, plus several other vertical, special, sectoral legislation. For example, even also the medical devices regulation is, of course, a risk-based regulation. But risk in the GDPR doesn't exactly correspond to risk in the AI Act, which doesn't exactly correspond to risk in the medical device regulation. How to put all these risks-based approach together is not so easy. Another big problem has to do with the development of standards. This is one of the tricky parts of these regulations because the EU legislators pretend to not only to develop but to impose their own standards via their organizations to the industry, and why not to the rest of the world. And either for geopolitical reasons or for the complexity of the field, because we are talking about thousands of different standards, this is another big problem. We have further issues of coordination with other fields of EU law. For example, one of the critical parts of this story has to do with environmental protection, which is a fundamental right in EU law. We have the Green Deal. We have taken the Paris Agreement seriously, so that by 2040, Europe must be carbon free. But the AI Act says nothing about environmental protection, which is up to self-regulation by a code of conduct of big companies, which is in a way incredible because, for example, when we get our Horizon 2020 grants in Europe, we have strict environmental duties. Namely, we have to declare that our project is environmental friendly, what are our plans be, what's our energy consumption, what it's our water consumption. And if your AI system is considered as a low risk use of AI, your private company has no environmental duties in Europe, which is a matter of internal coherence. And of course, there is this other big point, namely the resilience of this immense legislation, considering the pace of technological innovation. And here we have a very relevant warning sign. Just to be clear, I worked with the European Commission to write the AI Act. As I like to joke, the good parts of the legislations are those in which the Parliament followed our advice. The bad part of the story is when they forgot our advice. And a joke, but not so. And here's the problem. When I started working with the Commission in 2018, my strict question was, how much do you want this law to last? 5 years? 8 years? And the boss of the European Commission told me, no, Ugo, at least 25 years. Good luck. Why I say so? Of course, LLMs. When the European Commission presented the first draft of the AI Act in April 21st, 2021, they forgot about this family of AI models. So much so that after the first draft, they had to amend the legislation because you couldn't pretend to govern all possible uses of all possible families of AI systems, ignoring the new kid in town. And so, in fact, the last version of the legislation has a specific set of provisions, Article 51, 52, 53, blah, blah, specifically devoted to LLMs, with some very problematic, debatable provisions. For example, in some cases, there is the legal presumption that the use of LLMs trigger what's a new kind of risk, systemic risk. And how is this legal presumption determined? Well, by paying attention to a certain amount of computational power required by those LLMs. And by chance, the legal threshold set up by the AI Act is that of ChatGPT 3, not 4. So all LLMs are, by definition, considered risky. More specifically, they trigger a systemic risk for EU legislation, and as you can imagine, with a series of duties, obligations, blah, blah, blah. Of course, talking about LLMs, this was what happened to me. It was I died, well, by the way, over the past 5 years, every August 31st, I stay home. Thought it's superstition, but who knows? Just to tell you that, of course, LLMs are very relevant. 3 years ago, I was a part of the Japanese team at the G7 meeting in Japan. And so not representing Italy, but representing the, because all the digital ministers of the G7 were really worried about this kind of technology. Me too, after this hallucination. They apparently corrected and rumors about my death have been slightly exaggerated. But back to my previous question, will the AI Act could ever trigger a new Brussels effect? This, I think, is the interesting question for American scholars. Just in time for an interesting question. That is, my short answer is no, and so much so I published some years ago an article on why the AI Act will not trigger a Brussels effect. And the main reason has to do with the fact that this law is too complex, that it's hardly exportable to the rest of the world. And in many cases, so that in some cases, we may expect that there's going to be an international impact of this legislation on other jurisdictions. For example, considering some uses of AI which are prohibited in Europe, and I think even for very good reasons. In many other cases, consider, for example, the aim to develop unilaterally, to develop standards for AI. I think that there's going to be no Brussels effect for, I think, obvious reasons. NIST is working on the development of these standards as well. And let's wait and see. But so what I would suggest is the fact that we're going to have a sort of a patchwork effect. In certain cases, the impact of the EU legislation will be relevant. In many other cases, business as usual for the rest of the world, which means either China or the US. So, summing up, why a patchwork effect? Because I consider, in my view, AI systems and LLMs pose unique normative challenges that require legislation. I know what's going on in the US, but that's up to you. But at the international level, and I'm not referring only to the UN, I'm referring to several other organizations. The message is pretty clear. Certain uses of AI shall and will, and in some cases are already strictly regulated. So I think that some provisions of the AI Act are sound and are here to stay. But at the end of the day, I think that the overall design of this regulation is problematic. And in fact, as I told you, I stressed 2 years ago why the AI Act would have been amended before coming into force. And actually, that's what happened. That is, the European Commission started proposing the amendment of this legislation even before the AI Act is at full speed. Why? Because of certain defects are even embarrassing. Just to mention, in the first draft of the legislation, Article 8, if I'm not wrong, pretended that databases used for machine learning techniques, blah, blah, must be free of error. Since I learned from my sister that there is no such a thing like a hardware or software without bugs, I called the guy at the European Commission, say, you cannot pretend there is a good maxim of ancient Roman law. Nobody's held to that which is impossible. It has 25 centuries of history. It is obvious legal truth. And so I called the guys at the European Commission saying, you are crazy. You have to, in fact, this part. But there's many cases in which this legislation actually, if you suspect that they don't know what they are talking about in technological terms, you are very close to the truth. Of course, we have further geopolitical issues. You must not be blind. Let me recall you that in 2017, 9 years ago, a guy called Mr. Putin declared that who will dominate the AI world will be the world's boss of the world. It was pretty clear to Putin 9 years ago. Actually, there is this obvious competition. Another talk for next year maybe is going to be about what's going on in China. There is AI is, as you may imagine, is strictly regulated in China, but with a different approach compared to Europe. I'm not referring only to different values, democracy versus authoritarian state and the like, but also to significant differences of legal design. My suggestion to the Commission was to be, just for one time, more like the American model. Most of the time, either you don't regulate or US federal regulations are vertical, are sectorial, so that you are regulating life insurance, you're regulating medical devices, this kind of stuff. And in the case of AI, to me, this approach makes a lot of sense. Why? Because the pace of the technological innovation is such that if something goes wrong with your laws, you have only to amend a part of your legislation. Whereas in the case of the AI Act, you have this all-encompassing legislation so that the challenges of technological innovation are worse for the legislator. And how, okay, this is gonna be another talk. And as I told you, what's happening in the US is pretty clear to you. I'm referring to the regulation, or better, the non-regulation of AI. In the rest of the world, either at the international level or at the national level, most jurisdictions are very active. I told you in China, there is a number of strict regulations specifically devoted to the use of AI. And what? That's it for today. That's it.
Floor is open for questions.
Does the AI Act define AI?
Excellent point. At the end, do you want a short answer or the long story? No, because at the very beginning, first draft 2021, actually the definition was so general or generic that every kind of possible software at the end of the day could have been considered as AI. Nowadays, what's relevant to determine a threshold between software and AI has to do with the very notion of autonomy. Of course, in the engineering meaning of the word, and so the two most relevant properties are autonomy and the ability to adapt and to modify the inner states of the systems without a human intervention. The definition is in Article 3 number one of the AI Act. But actually, the key point is autonomy. And there is, I would say, a certain amount of consensus in the international community that this is the most relevant property to determine what's AI and what's not AI.
What happens if the databases are deliberately poisoned?
By whom?
Well, Google, Meta, Twitter, X,
Okay.
the US government, the British government, the Danish government, the Canadians, the Costa Ricans.
No. No, because I was thinking about the criminal side of this story. I mean, if you are talking about
non-criminal poisoners.
Which is the non-legal criminals.
Got it. Well, actually, you would be infringing a specific Article 8 of the AI Act, which pretends that your database should be free of errors as much as possible.
As much as possible. That's like almost
listen,
everywhere.
This is important because and then I will. So you would be infringing Article 8, and then you can be or you should be fined. And fines are up to 5% of your the annual revenue of your corporation, which in some cases, how to put it, it's an illusion because last year the Commission, the EU institutions fined Facebook for $2 billion, which is, you say, wow. And actually, the day after Wall Street, Facebook stocks were up at $3 million. So 2 million fine and 3 millions as a response to. So I agree that we will not solve these problems fining these companies. But back to your question. In this case, you have issues of civil liability, Article 8 plus fines. And we have something called the Digital Markets Act. And sooner or later, but this your problem in the US as well, we are discussing in Brussels how to tackle the de facto power of these companies by anti-monopoly provisions and what, for example, in the US is discussed as the public utility model, because several of these companies function as traditional infrastructures. And traditional infrastructures in most Western countries where a public have to follow a public utility model. So let's wait and see what happens in this case. But back to your point, short answer is civil liability, huge fines, that is some billions dollars, and if it has been done deliberately, even why not criminal law, jail. Don't forget that the first time that Google guy was before criminal law court was in Italy in 2006. Then in a very Italian way, he didn't need to spend 1 day in jail. But actually, the ruling was that the guy, at least formally speaking, should have spent some months in jail.
It's called a consent decree by the Justice Department. By the way, how do you find bias?
Find